I'm one of the few people who applied for and received a use variance for a home on less than 40 acres. At the time, I owned Stonehouse Park Campground in the southern part of the county. It was 32.5 acres, and the previous owner had subdivided off her home. At that time, not only did I want that use variance to go through, but the DeKalb County Sheriff's Department asked for that use variance to go through. The county board obviously accepted that, wanted it to go through. I'd have 2,000 people in my backyard at times, and somebody needed to control the situation. My point is, there are times, from what you said, even recently, there was 5 zoning variance uses granted in the last however many years. My point is, there are times when a use variance is appropriate, and if you take away that possibility, not only are you tying the hand of the residents and possibly business people in our area, but also your own hands, speaking to the county board, because you wouldn't be able to do something you perhaps would want to do. Everyone wanted this to happen when mine went through. And if the reason you're doing it is so that you can't get sued, whether that's because the judge may not understand the 40-acre rule or whatever the reason, frankly, that's just un-American. In my opinion, there's a reason we have separation of powers, and that's not a reason to get rid of this.
That's not the reason.
No.
That's written in the backup materials, that we don't want it to go to court because the judge may not understand the 40-acre rule.
That's not the reason why it's being proposed. The county's going to get sued regardless.
On that issue, but
on
in your backup material, the county board can read, there is a line about if we take away all variance, then it can't go to court, and a judge who may not understand what it means. So again, I'm asking that they not take away that possibility of a variance, because there are times when it's in everyone's best interest.
Just to clarify what Mrs. Mott is saying, she's referring to, in the narrative, it notes that if use variations are not an option, in other words, we take it away, property owners cannot go to the courts for administrative review. Now, administrative review is a specific kind of activity that in the state of Illinois is very unclear as to what the judge is being asked to do, whether he's being asked to take the place of the county board or simply review what the county board has done in making a decision. So it's ambiguous in front of the courts as to what administrative review is. By removing use variation, we remove that ambiguity that the courts have, not the county. So it's not a matter of being afraid of being sued, it's a matter of if we end up being sued, it goes to administrative review, and the courts sometimes don't even know what to do with that. It, of course, doesn't prevent a property owner from suing the county over not allowing the house on the property at all. They can always do that.
Okay, I still believe it impedes with the separation of powers. Thank you.
Thank you. Next.